All right.
My name is Bruce Bent. I'm a citizen of the state of Florida. I live in Tampa, and we're making this video to help inform parents of some of the problems that parents are facing, not only here in the state of Florida, not only here in Pinellas and Hillsborough counties, but all over the United States. It's important for you as parents to know and to realize the rights that you have, the responsibilities that government has, what the law actually says. And unfortunately, most people in government today don't spend time studying the law. They spend time studying court cases about the law. They spend time studying policies that are developed by administrations or the people who are their supervisors or whatever, without actually going and checking out the law. Today I'd like to talk to you a little bit and read to you from Chapter 39 of the Florida Statute, specifically Section 301, which has to do with the initiation of protective investigations. Point number 1 says, upon receiving a report of known or suspected child abuse, abandonment, or neglect, or that a child is in need of supervision and care and has no parent, legal custodian, or responsible adult relative immediately known and available to provide supervision and care, the Central Abuse Hotline shall determine if the report requires an immediate on-site protective investigation. Then it goes to point number 2, that the department shall immediately forward allegations of criminal conduct to the municipal or county law enforcement agency of the municipality or county in which the alleged conduct has occurred. The reason for this is because child abuse, abandonment, and neglect are crimes in the state of Florida. Because they are crimes, it would naturally go to a criminal investigation entity in order to find out if indeed a crime has been committed when the crime has been announced to the hotline. But the other thing is that because this is the case, certain protections go into effect regarding individuals that most people don't realize. And those protections are involved not only in the state of Florida, but throughout the United States under our national constitution, specifically our Bill of Rights. But it says, as going on with subsection B of paragraph 2, as used in this subsection, the word criminal conduct means a child is known or suspected to be the victim of child abuse as defined in Florida Statute 827.03, or of neglect of a child as defined in 827.03. A child is known or suspected to have died as a result of abuse or neglect. A child is known or suspected to be the victim of aggravated child abuse as defined in 827.03. A child is known or suspected to be the victim of sexual battery as defined in 827.071, or of sexual abuse as defined in 39.01. A child is known or suspected to be the victim of institutional child abuse or neglect as defined in Florida Statute 39.01 and is provided in Statute 39.302, subparagraph 1. A child is point 6. A child is known or suspected to be the victim of human trafficking as provided in Section 787.06. Notice that each of these is a criminal charge. It's a section of the criminal law of the state of Florida. It should be noted, and we want to make sure that people realize that because it's a criminal investigation, certain things and safeguards have to be put into effect in order to prosecute somebody who's charged with a crime. If the police don't properly investigate a crime, then that evidence gets thrown out. It's unfortunate that's the case. A person commits a crime, and because the police officer doing the investigation commits a crime, both crimes are thrown out rather than both crimes being punished and both of the individuals who are criminals being punished for the crime. We want to see to it, because child abuse, abandonment, and neglect are crimes in the state of Florida, that people receive proper punishment for those crimes. Only if they can be properly prosecuted will that happen. So there are certain safeguards that are in effect in the state of Florida and throughout the United States for crimes. When a person is charged with a crime, they have the right to be confronted by their accusers, which means that you, as a person charged with a crime or being the accessory to a crime, have the right to defense. which means you have the right to know who it is that's charging you, to know that you can raise issues regarding the trustworthiness of their accusation. The police are not supposed to begin the investigation of a crime to search for evidence, to find out if that person has or has not committed the crime, until there's probable cause. And probable cause, under the Fourth Amendment of the United States Constitution, is done by means of an affidavit sworn to by somebody, that for which, if their testimony is found to be wrong, they'll be charged with perjury, and that perjury can be proven because they lied. And that lie will then subject them to criminal punishment for lying. Right now, when it's an anonymous phone call on a hotline, and they act as though it doesn't matter who it is that raises the issue because the police do the investigation and then it's based on their evidence. Well, the evidence is not supposed to start until there's probable cause, supported by oath or affirmation, before the police get involved. They can't search for anything. And so, to see to it that criminals are properly punished, but also so that innocent people are properly protected, these safeguards need to be in place. So, one of the things that is required of every investigator as they begin an investigation, and it should be known that the department, under this same statute, the department's child protection investigators are hereby designated a criminal justice agency for the purpose of accessing criminal justice information to be used for enforcing this state's laws concerning the crimes of child abuse, abandonment, and neglect. This is why these individuals are a criminal justice entity, and therefore they have to abide by the restrictions regarding criminal prosecution, which means that a warrant has to be taken out in the proper manner, a search has to be conducted in the proper manner. These things have to be done, or the case has to be thrown out. But we don't want a case of child abuse, abandonment, or neglect thrown out and have these perpetrators out on the loose. But at the same time, we don't want innocent people to be charged with a crime as though it's not a crime, and therefore we can investigate it, and then if we find out that it is a crime, well, then we'll charge them. No, or that the children are taken away to protect against somebody that's being falsely charged with a crime. In fact, today, it's unfortunate, but in every case you have the right to trial by jury in the state of Florida, unless you are a parent charged with the crime, suppose not crime of child abuse, but just with child abuse, abandonment, or neglect, which are supposed to be crimes, but are treated as though they're not crimes. And you can be charged, lose your children, lose your parental rights, without ever being charged with a crime. Because the state has been abusing these statutes because they're not held accountable to them. The agency is, upon commencing an investigation under this part, this is subsection 5, the child protective investigator shall inform any subject of the investigation of the following. This is important, that they follow these guidelines because it keeps and protects the parents' rights. The names of the investigators and identifying credentials from the department. Because if they're improperly conducting the investigation, they're violating the rights of parents. They need to be prosecuted for that. Point 2, the purpose of the investigation. Why are they there? Where is the affidavit? Where is the probable cause that's causing them to initiate an investigation? Point 3, the right to obtain his or her own attorney in ways that the information provided by the subject may be used. It's important that you never be investigated without knowing that you have the right to counsel and knowing that that information you should have the right to have an attorney there to see to it that they abide by the law. 4, the possible outcomes and services of the department's response. Notice that most of these things were initiated as help to families that were in need of clothing for their children, of food for their children, of housing for their children, or whatever, because the family was in need. The state was given the ability to come in and to help those families by programs that were there. But these were all voluntary. If the family wanted them, the state could provide those services. And it's important to keep separate those things which are criminal charges from those things which are needs of a needy family. The right of the parent or legal custodian to be engaged to the fullest extent possible in determining the nature of the allegation and the nature of any identified problem and the remedy. If you don't know who it is that made the allegation, you don't know what the problem is, you cannot possibly know what the remedy would be to that problem. You don't even know who it was that raised the issues against you or whatever. All of those things are important. That's why we have those criminal checks in place in our Bill of Rights. You have the right to be confronted by your accuser. You have the right to know of the charges brought against you. You have the right to obtain witnesses on your behalf, and so forth. And all of these are there in the statute to make sure that they're protected. The duty of the parent or legal custodian to report any change in the residence or location of the child to the investigator, and that the duty to report continues until the investigation is closed. If the officers who are conducting the investigation don't let you know who they are and who to report to, there's no way that you can possibly let them know of your change in address or anything like that that you have the duty to respond to. And subsection 6, the duty of the parent or legal custodian to report. And then subsection B, upon commencing the investigation, subsection A, they have the responsibility to inform you of all these things. Subsection B, the investigator shall fully inform parents or legal custodians of their rights and options. These are not privileges granted by the department or the agency. They are the rights of the parents, including opportunities for audio and video recording of investigators' interviews with parents or legal custodians or children. Most of this takes place at the parent's home, and the parents are notified that the officer must come in and investigate the home. They must get the names and information of the children. They must see the children, interview them, and so forth, before they ever read the parents. The fact that the parents have the right to videotape, audio tape any of these interviews, either with themselves or with their children. This is to protect parents against investigators putting information into the children's minds or asking them questions in such a way that the children respond, and they edit all that information ahead of time. If the parents are allowed to make a video recording and an audio recording of this information, then it can be compared against any information or testimony that's given by the police officer, the person conducting the investigation later on. This is important for you as parents to know and to realize. You're going to see a video shown to you by Mr. Pound of an opportunity to try to get the agency to comply and realize that no, this is a right that the parents have to do this, not that the agency is going to do it and then maybe make those edited tapes available to the parents at some other time if they so desire. No, this is not. This is the parents' right to an option, that they have the right to audio or video record the investigators' interviews, parents, legal custodians, and children. The other thing is that one of the things that point number 7, it says that an assessment of safety and the perceived needs of the child and shall be conducted in a manner that is sensitive to the social, economic, and cultural environment of the family. This assessment must include a face-to-face interview with the child, other siblings, parents, and other adults in the household, and an on-site assessment of the child's residence. This is why it's very important that you know what the allegations are and so forth to decide whether or not you're going to allow access to your home, whether you're not going to allow access to your children or whatever. This is why legal counsel is supposed to be made known to the parents. The right to videotape and audio tape these interviews and the investigation conducted by them, to be fully participatory in every area, to be engaged to the fullest extent possible in determining the nature of the allegation. You can't possibly be able to be engaged to the fullest extent possible if you don't know who it was that made the allegation. You don't know what it is that they could possibly know or not know, or the circumstances surrounding the incident or anything else, if you don't know who it was that made the allegation. This is also, you have no right, you have no ability to confront them or to prosecute for maliciously providing false information or anything else. This is why these safeguards are placed in the Florida Statute, Chapter 39. I would advise any parent, before they allow anybody to get involved with them or their children, that you go online to the Florida Senate or the Florida House of Representatives, go to the statutes, download a copy of Chapter 39 and read it. Read the law. Familiarize yourself with it. You cannot be a law-abiding citizen if you don't know what the law is. The law has to be written in such a manner that you as an individual can know what your responsibilities are and what your duties are in order to be a law-abiding citizen. Familiarize yourself with the law. Make a copy of it so that you have it with you as a parent. If you're confronted, somebody wants to come to your house, conduct an investigation, see to it that you have legal counsel. See to it that you're equipped with audio and video recording and data. And if they feel uncomfortable with that, then it's them who back down on the interview, not you. It's important. It's important to you as an individual. It's important to the security, the safety of your family and your home. And it's more than that, it's important to the rights of every citizen of the United States and of the state of Florida. See to it that our rights are preserved and upheld, especially by those people who have the responsibility for protecting those rights. We need to see to it that they're held accountable for their duties and their oath of office. Understand that every one of these investigators has taken an oath to uphold and defend the Constitution of the United States, the Constitution of the state of Florida, and these are rights preserved and guaranteed there under both. Know this. Our desire today is to let you know this so that you can be protected and your family can be protected from arbitrary accusations, from things that should never ever have happened in the first place. The only way we can protect against these things is if we have the protection of the law. We have the protection of those people enforcing the law, protecting our rights as parents. Good day, and thank you for your hearing.
Okay, next we're going to interview the Child Protection Investigation Team from the Pinellas County Sheriff's Department, interviewing Greg Pound and Kathy Corey. Both of them are members of the Juvenile Justice Welfare Board for Pinellas County. And this was done October 2013. Here we go. Okay, this is Greg Pound with the meeting with the Pinellas County Sheriff's Department, CPI Child Protection Investigation, and charges that have been filed against me for abuse, child abuse, abandonment, and neglect. And I'm going to interview this with Ms. Marcy, the caseworker, or the CPI, and who's the other lady you have here?
I'm Kelly Karras, I'm her supervisor, so we're not going to allow the recording.
You're going to what? I'm sorry?
We're not going to allow the recording.
Who are you to say that we can't record?
Well, actually, if you want it recorded, you can come to our office.
I have to record at your office? Why at your office?
Because it's in more of a controlled environment. Because we just, you know...
Control for who?
It's in the rights and responsibilities pamphlet. It states it right in there that if you want to record it...
Well, the Florida statute right here says we have a right to audio and videotape, and you're supposed to inform me of that. Not tell me the opposite. This is the Florida statute. Now you're telling me, what is your name, ma'am?
My name's Kelly Karras.
Kelly Karras. Am I pronouncing that last name right, Kelly?
I'm sorry?
How do you pronounce your last name?
Karras.
Karras. Miss Karras here is telling me that I cannot audio tape or videotape this interview. And the Florida statute says, now we got this on video. We got it.
I'm simply telling you, if you want it recorded, we can certainly record it, but we're going to do it in a more controlled environment, so you can come to our office and set up an appointment.
Who's going to control it in your office? What's the difference between here or your office?
Because it's sheriff's office equipment that they will use to record the interview.
There can't be any tampering, that type of thing. It's something that we require.
There's no tampering? Well, the problem is, in my past dealings with the Child Protection Investigation Team, you've lost evidence, you've tampered with evidence, and matter of fact, you've even lied in court. You got Megan Gallagher, our case manager, filing 96 false reports. 96?
Okay.
But that's not tampering with evidence?
I'm not going to speak about the past, I'm going to speak about right now.
Okay, well, my dealing with you is based upon my past experience of dealing with you people. You're liars.
We're following what our procedures are.
Okay, that's great. So in other words, you're refusing to do this
You
interview.
can come to our office, it'll be...
You're refusing to... We scheduled this today.
Right. And we
Right.
have the interview, but we're not going to have you tape it.
Right. People have had to take off work. This lady here had to take off work to come to this interview. And you're getting paid for being here. And you're refusing the interview. Okay, Mr. Bent, do you have anything you want to, any closing statements on this interview that we just watched?
One of the things you'll notice is that the investigating officers did not volunteer to make known who they were, the authorization of the agency that they're with, or so forth. They did not make, they looked at the information not letting them know who it was that made the accusations or things like this, the accusations against them and so forth. All of these things should happen at the beginning of an interview. They didn't make the, it was Mr. Pound who brought up the fact that he had the right to videotape or audio tape the situation, and they said, no, if you want to have them taped, then we'll do it in our confines, under our control, and so forth and so on. Well, that's not the parent's right to do it. It's saying that the parent may have the right to do it, but it will be done by the sheriff's department, and those videos will be maintained or controlled by them, which means that whatever it is that's redacted out of it, and that kind of redacting is going to happen. Reading the brochure that is provided by Pinellas County Sheriff's Office for Child Protective Investigative Team says that your rights, you have the right to refuse an interview. However, what happens is if you refuse the interview, they're going to go ahead and conduct the investigation and so forth without you totally, but they're going to unfortunately assume that you've got something to hide instead of the presumption of innocence, which should be in our society now. It's a presumption of guilt if you don't succumb to whatever it is that they ask you to do. You have the right to refuse an interview. In such cases, the investigation will continue without input from you, and decisions will be made based on available information. An attorney may represent you at any point during the investigation. Not that you have the right to an attorney, but that an attorney may represent you at any point during the investigation. You may schedule a date and time for your interview for you and your attorney to meet with the CPI. You have the right to have the interviews taped, either video or audio. Not to have them taped, but you have the right to do that according to the statute. Should you make this request, notice not a demand because it's your right, should you make this request, a date and time will be scheduled in order to tape the interviews at the Pinellas County Sheriff's Office in a controlled setting, which means they have control, not you as a parent. It's not a check and balance on them. It's a means for them to acquire information without going through proper procedure. If you choose to delay your interviews in order to be represented or to have the interviews video or audio taped, the CPI will continue to gather information from other persons, including family members, in order to assess the safety of your child. The idea is that the state has looked on it as now that the safety of the child is their responsibility, not the responsibility of parents. If you are a parent legal custodian, must have court documents showing custody, or an alleged perpetrator, you are entitled to a final and closed copy of the investigation. You must come in person to the Pinellas County Sheriff's Office and provide photo identification and sign a confidentiality statement. Confidentiality means that the information that they show you, which may show that you were innocent or that you have the right to bring charge against somebody else, you can't use because you've signed a confidentiality statement saying you won't use it. You're just going to know about it. The report that you receive will not contain reporter information per Florida law, and sensitive and confidential information included in the report will be redacted, which means that that audio tape or that videotape or the report that's made or the names of who it was that accused you or the things that you should have in order to have a defense are not going to be allowed you. They can be redacted out of the information and the case can be totally closed without you ever knowing who it was who brought false charges against you, even if the case is dropped, let alone if it's carried through and you're prosecuted. And the idea is not that you as a parent have the right, but if your attorney presses for it, you may actually get it. But they don't want to give it to you as a parent, even though you are the one being charged, and your attorney shouldn't really count at all. Your attorney is only there if you can't handle your own defense yourself. Most people should be presumed to be able to handle their own defense because they know the situation better than anybody. You are the ones who are being charged. So understand that there are slants that are taken away from these things which are not given in the law and which violate clearly a person's rights under our Bill of Rights, and both in the national constitution and in our state constitution, which the Constitution is the limits and boundaries by which the government is held in check. Those things are there so that it protects and preserves our liberty, our freedom, but most of all, our innocence. One of the things is that we're to be presumed innocent until proven guilty, not the other way around. Not that you're presumed guilty based on somebody's anonymous accusation over a hotline somewhere until you prove yourself innocent. That's a whole violation of very key principles that are inherent in America's history of liberty and freedom, not wrongful charges and prosecution. Bless you. Know the law. Read it. Understand it so you can be a law-abiding citizen.